I should begin by explaining why the court is handing down this judgment on a Friday afternoon rather than in the morning as we usually do. The court has been advised by the Financial Conduct Authority, the FCA, that the outcome of this appeal, whatever it may be, may affect the price of securities issued by companies involved in the car finance market, and the market will need time to digest the judgment and consider its implications. In the county court, the customer's claims were dismissed, either by the trial judge or on appeal, insofar as they were based on bribery or on a breach of a fiduciary duty. No final decision was reached on Mr. Johnson's claim of an unfair relationship. The cases then proceeded to the Court of Appeal, which held that all the customer's claims succeeded. In the cases where there was no disclosure that commission might be paid, the Court of Appeal held that the payment of the commission was a bribe. In the case where it had been disclosed that commission might be paid, but not the amount, the Court of Appeal held that the dealer had been under a fiduciary duty and that its acceptance of the commission was a breach of its fiduciary duty, as the customer had not given his or her fully informed consent. In Mr. Johnson's case, where it's argued that the relationship was unfair, that argument was also sustained. So all the customers were held to be entitled to recover amounts from the finance companies equivalent to the commission which the finance companies had paid to the dealers. The decision of the Court of Appeal came as a shock to the car finance industry, as it conflicted with the assumptions which had been made not only by the industry but also by the FCA as its regulator. The finance companies appealed to this court. The FCA was permitted to intervene, as were several other parties. The Treasury also sought to intervene, but their application was refused, as their arguments concerned the economic consequences of the Court of Appeal's decision. The Supreme Court is only concerned with the legal issues in the case. In the period since the Court of Appeal's decision, claims management firms have encouraged anyone who bought a car on hire purchase or with a PCP to sign up with them. And no doubt a great many people have done so under the impression that they had a valid claim. But it was too early to form any view as to whether a valid claim lay on the basis of the Court of Appeal's decision, as the decision was under appeal, and it was only once this court decided the appeal that it would become clear whether the Court of Appeal had decided the cases correctly or not. For the reasons set out in detail in a judgment published today, the Supreme Court allows the appeals brought by the finance companies. However, we uphold Mr. Johnson's claim that the relationship between him and the finance company was unfair, and we allow the appeal in his case only because the Court of Appeal made a number of mistakes in reaching its decision. Retaking the decision on a proper basis, we award him the amount of the commission plus interest.